Hello, you English law, beautiful people, you. And I'm so pleased to hear that there are many groups forming and discussing the the English law, so that now they regain their power, which we have lost so often and so readily from birth onward to whatever age you are now. You can see that we're powerless against the juggernaut, which we classify as government. But then when we do comprehend what law is, we find that they were just merely a molehill to be kicked over. So I'm so glad that there's so many people, more and more people coming into interest and discovering what law is. This, of course, by having that ability, is going to put you head and shoulders above any lawyer, and I would assume most all judges, including positions like the Attorney General. And I'm going to share something with you at the end of this video. I hope I do remember that. You remember I always said that, with the gates unlatched, we just got to kick it open. It's been kicked open. So you got to make sure you get to the end of this video. So what we're going to speak about here today is the beginnings of the Settle Land Act. Yes, everything that was discussed in the English Law series, you could now, with that depth, start reading the Settle Land Act through your new eyes and your new comprehension, and start coming to terms of what actually it's saying and where your rights are. But I also did say that I'm going to continue on, and we're going to start breaking apart the Settle Land Act a bit so that we have a better comprehension of how to read it and the structure that's formed in order to establish the definition of why I call it the warranty, or a warranty. So let's begin. And perhaps the next video, I don't know if you guys experienced the same thing. I had a couple of friends confide in me, they did. And this was just around the end of October. It was like so many things bombarding in that was like, okay, you're ready for this, and the universe just gave us, you got like 5 different things going on. You're juggling all of it all at one time, where before it would have been insurmountable. It would just been, time to run, and hopefully run fast enough and far enough that you find yourself in a vacation spot somewhere on a deserted island, because there were so many things. I had like 4 or 5 matters dealing with bills of exchange. I was dealing with banks. I was dealing with that were trying to force their will. I even got pulled over. I was dealing with cops who were trying to get contract. I was dealing with towing. I was even dealing with somebody who is engaged in the English Law series, and that was dealing with a court case, who used a bill of exchange and then had to go to court, to which a lawyer was trying to induce some other means in order to get contract, which is he was trying to get through bankruptcy, and we were able to subvert that bullet to move on to the next. And there were just so many things. So I don't know if you guys experience the same thing. It's like the universe, I don't know if it's, I don't know, call it karma, whatever you want to call it, whatever it was that needed to be settled, and then begin. It was like a new beginning. It was like an end to all the things that was happening, and then whammo, it had to all it had to go coalesce in a moment, and then now we're branching off in more of a singular direction, because that singular direction is now met with the comprehension of what law is. And it's, of course, now it's not fear-based at all. It's with knowledge. Okay, now I wrote some things down here. Begin. Hopefully not to get too off track. Since I got to change things, I'm going to just give me a moment. All right, Settle Land Act 1925. Now, this first part I copied from the Law Reform Commission of British Columbia, Article LRC 99, and it begins, at one time it was common for a person who owned land, and remember, when we speak about land, this is only ever an ownership of it. This is only accomplished through the capacity of a tenant. Okay, so always keep that in mind, that there is no position or title except for the sovereign itself that doesn't go through the capacity of a tenant. Okay, so I'll begin, instead of carrying on, I'll begin again of that first sentence. It says, at one time it was common for a person who owned land to wish to control its ownership long after his death, often with a view to ensuring the family holdings remained in the family. Two methods in particular were relied upon to safeguard family holdings. First, property could be transferred to a person in trust to hold the land for defined purposes and for the benefit of particular persons. Second, limited interest in land could be conveyed to a series of people. For example, a person might leave land to his son B for his lifetime and then to B's children. When ownership of property is structured in either of these ways, it is said to be the subject of a settlement. The land is settled. Settlements of land sometimes involve very complex arrangements of title and create a number of problems, unquote. But what we're interested in is the beginning settlement, the origins, the original settlement, which is that legal interest in land, or the legal estate right to a interest in land, which is subject to what we classified as the strict settlement. And we're going to get into that little bit of that primary word, okay, and of its importance. But the common law, as I continue here, and wrote, the common law, though, was subject to strict rules of inheritance, so meaning it didn't have anything to do with trust. And so you could control it in the same mannerism as the as the want to control it, and that was only exercised through creating trust. Okay, so again, the common law was subject to strict rules of inheritance, and so these large settlements, subject to inheritance, were determined through law only as to how they must be transferred, and so were not to be transferred according to the will of another through device. Nor were these type ownership in land available to be transferred into a trust as we now know them, as this is an equitable pursuit, not a matter of common law. Essentially, we are speaking about those bloodlines originating from times of the conquest of William the Purchaser, William the Conqueror. And at the same time, after that purchase, the curia regis was formed during the epoch of the feudal times, which evolved into what we now know today as the Lord's Temporal and Lord's Spiritual, essentially the foundations of Parliament. The settlement culminating into the Settle Land Act was termed a revolutionary act because, like quoted in Encyclopedia Britannica, it states, the act itself essentially gave more power to the present holder than the common law did, unquote. Now, why is that? Well, as we have come to know, the power was all put into the tenant for life, which was essentially a beneficial trustee right. And again, we're going to pack that a little bit more for some more depth. Okay? A larger issue that arose concerning these large strict settlements in common law was not only how to control through the intent of the will of an owner, but during the life, how to make them available for discharge or for sale, as they were very costly to hold. And when they were transferred into the heir, for instance, through inheritance, they were often met with charge of incidents and marriages and warships and all those different sorts of things. So it was very troublesome for the heir to take control of. He often received an estate less than what his father had before his father died, because it was all subject to these different various costs and commitments. Now, no, I just actually didn't do that. Okay, now where am I now? Of course, all matters had to be settled with creditors as well as we moved into further down the timeline of the feudal time and into the ancient and before we arrived to modern. But there were many things to be settled before it could be transferred into the heir, such as those things we're dealing with creditors. Okay, and this had to be completed, of course, thereby, in most cases, leaving the heir unable to meet those requirements or even to negotiate on behalf of his inheritance to be able to settle the matter according to the interests of the creditors. And this could often lead to sorry, I just lost something here. Could often lead to the heir himself losing his entire family inheritance. Okay, and let's face it. I mean, not all fathers are great with money. I mean, the father could be a gambler, or he could be, for other reasons, severely in debt. So, at that time, before the heir could receive it, as we all know by looking at today, all the creditors had to be satisfied, and through those means, he was left whatever was left, and or whatever's left, collecting dust in the attic or in the basement or in the garage. And we know how that all goes, right? Okay. Now, before we continue, it may be perhaps in all of our best interest to stop referring to terms like common law and equity, as we are now familiar with their origins and their interests according to subject matter and status. We've covered that through the entire English law series. And the reason why, to help us, converse with each other, and of course moving into standing before a competent judge, if we're exact in our words, therefore not creating ambiguity, we then now invite the ability to deal directly with what it is that we're there to speak to or there to settle. So many times, and I see it all the time too, I'm using the words common law. Well, there's different, as we have come to comprehend, there's different types of common law. You can have the common law equitable interest. You could have the common law, the territorial common law interest. You can have the English common law based on its origins. And then, of course, we've got different things in equity, and where, again, there's that who's on first, Abbott and Costello, who's on first, what's on second. That the same terminology has been used in citizenship and under governments, also used by the Crown and Parliament, and then we got the monarchy, and then we're talking times of when those interests began in the first place, and we've got all these customary and common laws and these nuances that then create confusion. So this is what I invite you to now assist, and I just came to terms with it myself, speaking to others, and I said, yeah, that's great. I think that's a phenomenal idea as we continue to move the impurities in order to arrive at the gold, so that now we're only speaking to gold. We're not speaking to other things that are impacting our ability to want a certain desired result, and that desired result is not being met because someone is interpreting it in a different matter than what you are trying to express. Okay, I went off a little bit there, and I'm going to sort of repeat it when I keep on. I'm going to go back to what I've written down here in my own narrative. Okay, where am I? Now, as we recap and we go from AD 1066, and those times settlements, and it was settlements. Each one's a matter. It's a settlement. It was based on tenure and status. And then today, we move into free and common soccage regarding technically one's life and status. Okay? And we have evolved into now just terming the entire of everything into two words. And I already said it before, is the words strict settlement. Through invoking this effort, then the law that governs that beast, the strict settlement, and is our primary interest in this English law series, will annex itself automatically to the type of law necessary to assist in vesting our entire dominion right. Essentially and primarily, the strict settlement was established from the abdication of the throne of James II, which qualified the end of the despotic monarchy, and the introduction of the crown in Parliament, aka the institution of the constitutional monarchy, and there's the beginning of the new settlement, the strict settlement from that point on. Okay. Bill of Rights, 1688-89, was the end of the Glorious Revolution and beginning of a new epoch in the rights to land. This is the origin of the strict settlement, not subject to a trust. Its warranty, as relates to the different capacities, are divided accordingly. The tenant for life is the beneficiary trustee, has all the power, and if not held in the T for L immediately for the reasons not known. What I mean is not knowing where that tenant for life hasn't shown, hasn't exercised their will, or that tenant for life is dead. They were then transferred into statutory owners or trustees or personal representatives through operational law or court order. Now I have to also include, I just said for reasons not known, but if you're an infant, that's where statutory owner came in, because the tenant for life at that stage wasn't, even though it was annexed to the life, it wasn't enacted until that infant became of age in order to effect those rights as a tenant for life. Okay. Now the tenant for life is an equitable position. To see the problem we face, I keep on speaking to the fact that it's common law interest, but essentially, just think about it. And it came to me only just over a month ago, speaking to the guy that I stand, of course, like I said, I stand on the shoulder of a giant, who then stated how they've directed and concentrated and wanted to speak to the matter at hand by not getting caught up in using terminology of common law and equity, but just saying, hey, we're interested in a strict settlement. And so it makes so much sense, and it cleans things up so well. Okay? And being that the tenant for life is an equitable position, it may have been discussed in a matter which placed them directly in it may have been discussed whereby, when I'm reverting to it as a common law interest, that it is essentially a common law right that we're dealing with, but it's the tenant for life at that moment who's holding the entirety of the settlement, but in a beneficial way and as a trustee. And as we already know, those two positions are not strictly from the common law. Essentially, they are an equitable position, so it creates confusion. Okay. Now, moving on here. And as for them being in a trustee position, that is for those interests of remainder, which we don't speak about, because that's nothing to do with what we want to affect. We are only interested in the reversion of the strict settlement held through the devise incapacity of a tenant for life, through the civil death of the beneficiary, which automatically exhumes the position of the settler through that process. And we'll get into that sometime later on. But anyways, now explain it in this way, and as I carry on, and I'm going to repeat some of the things again, but now I'm reading back from my notes. Explaining it this way has only come to me most recently, as I just mentioned. It is the settler who is subject to common law. But again, we are now wanting to remove from defining that type of law, such as common and equity, and then instead swap and insert the words strict settlement, so as to then invite the law that governs such a right. This allows a means of entry that then transfers the burden over to a competent judge to then effect the laws necessary in order to move towards terminating the strict settlement, not subject to a trust. It is also of importance to note the qualification after I say strict settlement with the following words: not subject to a trust. Not subject to a trust essentially means that the original interest belonging in the right of the settler is not held in trustees, and so separates those settled estates in equity, namely the act entitled Law Property Act 1925, which is subject to the settlement under a trust for sale, and thereby and thereby evidencing rights of a trustee rather than those of the tenant for life. So when we speak about tenant for life, that is, even though it's a trustee position, it is not held in trustees, and therefore we speak to the mannerism of the strict settlement, because that is why it's not subject to a trust, because that position is not, or that interest of the strict settlement, that legal estate, is not then held in trustees. The only way in which we're speaking to a trust is if through the instrument of a trustee is holding that legal estate. Now we're speaking to a trust, and subsequently every estate that's created under a strict settlement is subject to a trust. That which separates that interest of the tenant for life and that interest for those available for purchase, which is then is completely severed through a trust instrument. Okay. So not subject to a trust, sort of said that. I expect the next video that we're going to speak to will now invite a dissection of the Settled Land Act, so we get a better feel of how it begins. And even when you start reading acts besides the Settled Land Act, and you start going through the concept of filtering through how a trust is set up, like through the three certainties, intent, subject, and object, you're going to see a lot of the acts. I don't know of a lot because I haven't read piles of acts, but they always do an introduction or preamble, that then gives what the intent is. So isn't that how the beginning of a trust is set? And then it starts speaking about the subject, so that is essentially the res. And then what is the purpose of that act, which becomes the benefit of the intent. So you can see how act you start reading it through a trust mind, as opposed to just reading it through through as a means for which this act is all about. You are now saying, okay, here's locating another trust, and then through that, reading that law, you will then have a better ability to separate between what a trust is and what a contract is. Okay. Now that's primarily all that I want to speak to in this video. And if you haven't done so, smash that like button and subscribe. You guys know as much as I do about the importance of doing that, because the more that often that happens, we're going to get this information out. And the more people that know, now we're creating a group of independents that now has more authority and more ability than those who are stuck within their oaths and their confinements of agency and being subject to the monarchy or whatever it may be that they're entertaining and overreaching their natural rights. So meaning is that we really got to get this information out, because we got to start building our own communities now and start building onward through abundance and through methods of using free energy and having all those things available to us now, because we've got to begin where this world is now ending. Now, when I say now ending, I mean it's, as you know, that is tightening and constricting upon the rights of people, whereby no one is going to have any property rights in order to have a voice, and we're going to be stuck into these, are moving into these 15-minute cities, concentration camps, essentially. Okay. I did mention at the beginning of the video I have some other news to share. I said, that through the English Law series, I unlatched the gate, and now we've kicked it open. So, without giving you lots of information that I have not been given permission to speak about, I'm going to say it in this mannerism. Two people that I know of and I spoke to over my tenure with my mentor, and to which we're now discussing things again. Two people have entered courts in Canada, one in Quebec, in the province of Quebec, and the other in the province of Ontario, to which they are speaking. One who speak to the strict settlement, not subject to a trust, and they were able to only speak to that matter in a way that all of their entry through petition was supported by footnotes, so that when a judge was, you were giving all, essentially giving the entirety of the law, transferring the law over to the judge to make an easy determination, which then was removed of any ambiguity, which is, of course, equity is well renowned for, and that's why we have these courts of chancery, where by looking at it, they knew exactly what the law was and what that interest that was being brought before them. And having done that, they invited the Office of the Attorney General to attend in this matter, and in both cases, because what you do is when you create a petition in court, you're allowing the other party to then, give out to defend or to discuss some of the issues they may have. Well, in both cases, the Attorney Generals didn't even participate. They just tapped out, essentially, okay? And one of those cases, being in Quebec, I believe it was, the Attorney General was on the phone with the party for about an hour, getting a feel of what was really going on, to the point that it is now moved. One of the matters have moved into the Attorney General doesn't have the competence to speak to the matter. Okay, that's what I speak. That's what we're talking to here. That's the power that you're going to have by putting your energies into law and comprehending what that is. You are now eliminating all those muddy waters that are lost in trying to discern who's responsible for this or that. By bringing in that matter, you just eliminated the positions of the Attorney General. To now that both of these petitions before the Crown have moved up to only speak to Settle Land Act, and that was the major problem, was trying to get to that point. How do we access only that law, and only those laws pertain to Settle Land Act? And that was been difficult. That was that hurdle to try to get through, so that when we go to court, we're not they're not trying to commingling matters and so forth, and they're already stuck in that robe that they have to speak to Settle Land Act only. So they have now advanced to the next level, whatever that may be. Of course, it might be before 3 judges, a tribunal of some sorts, to only speak to the matter of the Settle Land Act and work towards settlement of that legal estate that is put into each of us at the matter or at the moment of birth. Okay, so I wanted to share with you exceptionally more than exciting news, being that the door is now kicked open. It has allowed me to start working on my petition, which is my biggest hurdle, is making it simple. And then I want that done within about a month. So now I'll also be ready to have a court date for me to be standing before a judge, and so I can start the process. And hopefully by that time, that process has already been dealt with in some mannerism. And we don't even know. This might have to go to Supreme Court of Canada. Okay? We don't know yet. But we do have to do what we're doing, because obviously if we don't, look where we're going. Okay? We're going to be caught in the whirlpool of this mess. Moving into settling the trust for sale. Actually, in 1996-97, you couldn't even create strict settlements anymore. They have now moved into a trust of land and appointment of trustees act, and we're moving into that new epoch of trust of land, and that's what is the evolution of the trust for sale being settled. So with that, remember, smash that, hit it. I don't care how you do it, but hit that like button and subscribe if you haven't done so already. And please, by all means, keep up the good work, guys. We're getting there. With that, Godspeed. Have yourself a wonderful evening. or morning, wherever you're at.